Imagine you're sitting on the couch at home. There's a loud knock at the door. You go to answer it, and there's a group of armed law enforcement officers barging in, guns drawn, telling you they're there for your guns. They hand you a piece of paper, and they start ransacking your house. And all you can think is, what the heck is going on? Well, it's called a gun violence restraining order, or a GVRO, and it's the law in California.
Current existing law, which was AB 1014 from Assemblymember Skinner, was implemented this year, was modeled after California's domestic violence restraining order procedures. Existing law allows a law enforcement officer or an immediate family member to petition the court to issue a gun violence restraining order prohibiting dangerous persons from having a firearm.
It allows family members and law enforcement who believe that you might be a danger to yourself or others to petition the court to suspend your right to keep and bear arms. They hold an ex parte hearing, meaning you can't be there. In fact, you don't even know about it. The judge can then issue a GVRO along with a firearm seizure warrant, giving law enforcement the ability to search anywhere they think you might have a gun. Sounds pretty bad, huh? Well, now there's AB 2607, which would expand the universe of who can request these restraining orders.
Our bill expands this logically to include an employer, a coworker, a mental health worker, an employee or an employee of a high school or college.
That's right, it expands the list of who can request a GVRO to include mental health professionals, your boss, co-workers, your college or high school teacher. I mean, we're talking about thousands of people. I mean, virtual strangers.
If you are at a college, you're talking about up to 10,000 people that attend a college or a university with this particular individual, all of which would now have that ability. If we're talking about coworkers, take for example the California State Legislature. Over 2,000 people work within the California State Legislature. It has now been expanded to include those folks who may have very, very little contact or very close relationship to that individual. And I'll also just finally note there's nothing in the current law that prohibits those individuals from going to the immediate family members or law enforcement in order to express their concerns in order for them to be able to potentially seek a gun violence restraining orders.
The bill is such an infringement on our civil rights that even the ACLU had to come out against it.
So what this would allow is that a coworker of any of us could by themselves come into court and obtain an order from the court without notice to the restrained party, so they would have no opportunity to be heard at the hearing. And they could obtain an order that says that it is likely that the person is armed and dangerous. That order would then be given to law enforcement. Law enforcement would serve the order on the person, and we can imagine the fashion in which, it might not be a casual encounter if that's the information law enforcement has been given.
The measure is such a mess that even the mental health professionals want it out.
Our concern about this bill is it's going to, with all due respect, muddy the waters for therapists. It's going to create this tweener situation where perhaps the danger doesn't rise to the level of a Tarasoff or 5150, and it's going to, unfortunately, in our opinion, expose the therapeutic relationship to breaches where it probably shouldn't have to occur.
The opposition to AB 2607 was so overwhelming that one of the most anti-gun members of the entire state legislature changed his position and opposed the bill.
I had come here without thinking I would vote aye. However, after listening to all the testimony, I'm not going to be able to support the bill. I've always said to my staff, don't schedule meetings during a hearing because I want to hear what the witnesses have to say. And this is one time when the witnesses really have changed my mind.
Unfortunately, AB 2607 got out of committee, but it was largely because 3 members of the committee weren't even present during testimony, one of the very rare hearings where testimony actually changed the vote. So they simply voted the party line. Well, now it's on the floor of the Assembly where you can help us kill it. Go to firearmspolicy.org, that's firearmspolicy.org. Sign the petition and tell the State Assembly to vote no on AB 2607. This is Craig DeLuz in the FPC Newsroom. Thank you for watching.